The U.S. Supreme Court has just issued a major ruling.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
Everybody has a right if they're a responsible adult.
Silence can save you. Imagine these flashing lights in your mirror, a calm officer approaching your window, and suddenly a simple sentence slips out that changes everything. In the world of concealed carry, it is not just about what firearm you carry or how you carry it, but what you say when questioned. One wrong phrase can turn a routine stop into a criminal case. This is not fear-mongering. It is reality, and it happens every single day across America. Most gun owners believe their permit protects them, but what really protects you is what you do not say. Today, we are revealing 5 things you should never say to police if you are carrying a firearm based on real-world cases and legal breakdowns from experienced attorneys who have seen these situations go horribly wrong. If you are a responsible gun owner, this video could be one of the most important things you watch all year. You are watching Survival Firearms, where we keep you informed, aware, and legally prepared. If you value your rights and want to stay ahead of the changing landscape, hit that subscribe button and join a community of serious gun owners. Let's get into it. Mistake 1. Firing a warning shot could land you in court. At first glance, firing a warning shot might seem like a responsible way to de-escalate a threat without hurting anyone. Many well-meaning gun owners believe that a bullet into the ground or the sky signals restraint. But in the eyes of the law, it is often treated just as seriously as shooting someone. Across most states, warning shots are considered a use of deadly force. The law typically does not care what your intentions were. What matters is that you discharged a firearm in public, and that alone opens the door to criminal prosecution. Real-life example. In Texas, a man fired a shot into the air during a home invasion. He never aimed at the suspect, and no one was hurt. But police still charged him with deadly conduct. The justification? The intruder was unarmed, and the use of a firearm was seen as reckless. Here is why warning shots are such a legal danger. A bullet fired into the air or ground still has to land, and it could seriously injure or kill someone. Prosecutors may argue that you acted impulsively or without control. It undermines your claim that you were in immediate danger. When police arrive and hear gunfire, they might treat you as the aggressor. If deadly force is legally justified, the law typically expects you to aim at the threat, not fire into the air. And if deadly force is not justified, then you should not be pulling the trigger at all. There is rarely a legal middle ground for warning shots. It is either lawful self-defense or it is not. Always check your local laws, but as a general rule, never fire unless you are fully justified under the law to use lethal force. Mistake 2. Saying too much can turn you into the suspect. When officers arrive after a use of force event, your first instinct may be to explain everything. You might say things like, "I was just defending myself," or "I did not mean to hurt anyone." You are trying to stop the situation from spiraling, but legally, talking too much, especially without a lawyer, can do far more harm than good. Police officers are trained to listen for specific language that can be used as evidence against you, and under stress, you might say something you never intended, or your words may be taken out of context. Real-life example. In Georgia, a man told police, "I just wanted to scare him." That single line was enough for prosecutors to claim he was not in real danger, and his self-defense argument fell apart. He was charged with manslaughter. Here is why talking too much is a legal trap. Anything you say, even if innocent, can be misinterpreted and used against you. Your version of events might not match video footage or witness statements. Officers take summaries, not transcripts. You have no control over how they write it down. A casual explanation can be twisted to imply intent or even premeditation. Instead, give only the essential information. Your name, your ID, and a clear statement that you are asserting your right to remain silent until an attorney is present. Say something like, "I would like to speak to my lawyer before making any statements." This is not suspicious behavior. It is the smartest and safest legal move you can make. Silence cannot be held against you, but a single careless sentence could cost you your freedom. Mistake 3. Consenting to a search. It often starts with a casual question. An officer asks if they can take a quick look, and you think there's no harm because you have nothing to hide. But the moment you agree, you voluntarily give up one of your strongest constitutional protections under the Fourth Amendment. Once consent is given, officers no longer need probable cause. They can legally search areas you never intended, including your vehicle, bags, and sometimes parts of your home. Anything discovered can be used in court, even if it has nothing to do with the original stop. Real-world example. In Missouri, a driver was stopped for a broken taillight. He agreed to a search. Inside a backpack, officers found ammunition. The driver was a prohibited person, even though the ammo was not on his body. That single yes turned a traffic stop into a serious federal charge. Why voluntary searches are so risky? You cannot undo consent once it is given. Officers may search more areas than you expected. An item you forgot about can suddenly become evidence. Even dismissed cases can leave behind legal costs and records. What you should do instead is simple and lawful. Calmly say, "Officer, I do not consent to any searches." That statement protects your rights and requires officers to follow proper legal procedures. Innocent people may have nothing to hide, but they still have everything to protect. Mistake 4. Drawing too early. Tense situations escalate fast. Someone is yelling, approaching, or acting aggressively. You feel threatened and instinctively reach for your firearm, believing it might stop the situation before it gets worse. But if the law does not justify that action at that exact moment, you could be the one facing criminal charges. In many states, drawing a firearm, placing your hand on it, or displaying it without immediate legal justification can be charged as aggravated assault. Intent does not always matter. Perception does. Real-world example. In Arizona, a man drew his firearm during a road rage confrontation. No shots were fired and no one was injured. But the other driver called the police and claimed he was threatened. Despite having a valid carry permit, the man was arrested and charged with a felony. What the law expects you to understand, you must face an immediate and unavoidable threat of serious harm. The danger must be credible and specific, not emotional or verbal. Witnesses may only see you holding a firearm, not the full context. Video footage can remove critical details and favor appearances. The correct approach is restraint and awareness. A firearm is a last resort, not a warning tool. Drawing too early can instantly reverse roles and place you in legal jeopardy. Carrying a firearm means carrying responsibility. Knowing when not to draw is just as important as knowing how to use it. Mistake 5. Assuming all states follow the same rules. You are on a road trip carrying your concealed firearm legally under your home state's permit. Suddenly, a threat appears and you act in self-defense, doing exactly what you've been trained to do. But instead of being hailed as a responsible gun owner, you end up in handcuffs all because the laws changed the moment you crossed a state line. What's legal in your state might be completely illegal just a few miles away. Here's why this assumption is dangerous. Some states support stand-your-ground laws, others require you to retreat before using force. One state may consider your vehicle part of your castle, another may not. The legal definition of reasonable force varies drastically from state to state. In certain places, even warning shots are classified as criminal acts. Prosecutors may treat you as the aggressor simply because their laws don't match what you know. Real example to remember. A Pennsylvania resident lawfully defended his family during a home invasion while visiting relatives in New Jersey. Back home, he would have been completely protected. But New Jersey's stricter laws led to his arrest, serious charges, and a six-figure legal battle, all for an act of self-defense. What you should do instead, before traveling with your firearm, study the specific laws of any state you plan to enter. Read the statutes directly, or better yet, consult a qualified attorney in that state. Never assume your permit or training applies everywhere. Just like speed limits change between states, so do self-defense laws, and the consequences of being wrong are far more severe. When it comes to carrying across state lines, legal knowledge is your first line of defense. Be silent, be smart, be free. In the world of responsible firearm ownership, your words can become weapons used not to protect you, but against you. What you say or do not say can shape the entire outcome of a police encounter. That is why silence, discretion, and awareness are your greatest allies. You do not need to argue or lecture officers. You just need to know your rights and use them wisely. By avoiding these common traps, you are not just protecting your license or firearm, you are protecting your freedom. This is survival firearms, where your rights matter and your knowledge keeps you safe. If you learned something valuable today, hit that like button and subscribe for weekly breakdowns that every American gun owner needs to hear. Stay smart, stay safe, and we will see you in the next video.